We've had lots of questions about the importance of attorney-client privilege, especially as it pertains to an emergency self-defense situation. You want to learn all about it? Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We are the attorneys for freedom here today to talk about a question we've been asked a lot about.
Yeah, this happens. People send emails to me. I put my email in almost every video. And when we start seeing questions that are similar, lots of people are asking, it makes sense to just do a video and blast it out. So that's what we're up to today.
Yeah, if you take a look at the videos we've released over the last few months, a lot of those videos were specifically tailored to, you guys have been asking us a whole bunch of questions about this, so let us break it down. We like doing this, by the way. It's one of my favorite things to do.
I was just going to say the same thing. We love being lawyers. That's our primary mission, and we love talking about our craft and what we do and what makes sense and what doesn't make sense.
It's also really efficient for us to do it like this rather than respond to each individual email. So bottom line is keep sending us all your questions about our program and any questions you may have about the law in general, and we love making videos about them. But today's topic, Marc, is about the importance of attorney-client privilege. And as I proposed before we started the video, I think before we even jump into that, we should talk about it generally. Why do we have attorney-client privilege?
Yeah, I think stepping back for a moment, there are two things that get confused sometimes. There's attorney-client privilege, and then there is the attorney's ethical duty of confidentiality. And they're different things. I guess let's start with the ethical duty of confidentiality. This is essentially the fact that lawyers, and not just the lawyers, but paralegals and all members of a law firm, have a responsibility to keep all aspects of a client's case entirely confidential. And it doesn't matter where we get the information from. And it doesn't matter if the information's already out there in the press. Whatever we know about a case or a client, which includes the fact of whether we even represent somebody.
Them, right?
Yeah.
This happens at our front desk a lot. A family or friend will call in. That person has maybe told them that we represent them, and they call in and they say, hey, I'm their friend or I'm their aunt, or I was just wondering if you can tell me about the case. Not only can we not tell them about the case unless our client has explicitly authorized to do so, we can't even acknowledge that we represent that person.
Yeah, which is why, it took me by surprise a little bit. Maybe this is my own fault. When we started putting out those emergency contact forms and people started asking questions, are you guys going to use this for marketing or is it going to go somewhere else? And this is so far removed from what we're allowed to do. It didn't even actually cross our minds that people would even think this. So yeah, if you're a member of Attorneys on Retainer, then you got an opportunity, a request even, to fill out this long form called an emergency contact form. We already did a video on that explaining what it is, but essentially it gives us information that we need so we can argue for release in an emergency situation, i.e. there's an incident, police come, you get arrested, you're going to go in front of a judge pretty quick. We need a full package of information. That judge wants to know, is this person a flight risk? Is this person a danger to the community? What are their priors? Do they have access to firearms? If I let them out, is there someone in the community who can sort of assist them? Those kinds of things. And so some people just filled it out and send it back, and other people are like, why do you need this information? What are you going to do with it? I don't want to be getting solicitations from them. And so,
to be fair, for people who aren't accustomed to working with lawyers in a law firm, there are lots of companies out there that would take this information and use it for marketing purposes. So to be fair, I can understand why some people were suspicious about that.
People maybe don't often deal with law firms, but it's different when you're dealing with a law firm. We're held to a completely different standard. If we took confidential client information, which is essentially any information, whether it comes from the client or anybody else, and used it for some commercial purpose, we'd be in big trouble with the state bar. So would every other lawyer across the nation. I'm not breaking any new ground here. If there's any lawyers listening to this, they're all smiling because this is Lawyering 101.
Yeah, just to kind of really tie this point together. Anytime you have seen us on this show talking about a case that we have had, maybe a high-profile case or something like that, we have had to obtain specific waiver from the client to discuss it on an electronic means, which will be put on YouTube or something something like that. Like, the ethics rules are extremely stringent, and if you don't follow those and you're kind of willy-nilly about this type of thing as a lawyer, it's the type of thing that gets you pulled in front of the bar to defend your license. So as it turns out, most people don't want to be used for marketing purposes. And what I mean by that is most people who are charged with a crime who come to this law firm are coming to us to represent them in usually something. It could be something tragic. It could be something very consequential, very heavy, the most important consequential thing that they've ever faced in their life on many occasions. And the last thing on their mind is, and I want all this information about my very serious case to be put out to the world so that the Attorneys for Freedom or AOR can use me for marketing. And understandably, for that reason, we can't just go and blab on the internet about each and every client's cases. Now, there are some general things we can say. We can say, for example, yes, we have numerous AOR clients. Yes, we have represented people all over the United States pro hoc vice. Yes, we have active cases right now in multiple states all over the United States in self-defense matters.
AOR clients.
That are AOR clients who were in active self-defense matters. But that's all we can say, absent their specific permission.
Yeah, and it's understandable that people might say, look, this isn't something I want to broadcast. We can't pressure people and say, oh, come on, it would mean a lot to us if we could put you in front of a camera. Some people want to talk about it, and if they do, fine. And even if they do, if we don't think it's in their interest, we're going to counsel them against it, even if it would be in our interest to put it out there, right? Like I've said on many occasions, we're lawyers first. And we got to give good advice to the clients.
All right, so all of that is related to the completely separate issue of confidentiality, which oftentimes gets confused with attorney-client privilege. Marc, what is attorney-client privilege, and why do we have it in the United States?
Yeah, the attorney-client privilege really is the client's privilege to keep the lawyer off the stand. And if you think about it, if we didn't have such a privilege, well, then anything that a client said to a lawyer would be discoverable. Like, you couldn't talk to your lawyer. You couldn't.
What do you mean discoverable? Let's break it down. No legalese. Throw all that stuff out. Let's talk in just plain language.
It means the prosecutor could send a subpoena to the lawyer at the trial to say, get on the stand, and I want you to tell the jury everything about what your client told you in regards to this case.
Yeah, let's talk about that. So when cases are going to trial, when both sides are gearing up, and this is true for both civil law and criminal law, both sides are kind of investigating everything. And oftentimes, as the defense, we might be using a private investigator or something like that. A public defender might be using a court-appointed investigator. But prosecutors oftentimes use their agents, which is the agents of the state, i.e. law enforcement. And law enforcement can go around and investigate. But sometimes the prosecutor has to get the court involved when they're investigating and try and go get records that a police officer may not be able to get without certain levels of evidence that we call probable cause. So what a prosecutor will do sometimes is the prosecutor will go to the court and ask for something called a subpoena. This is just basically an order from a judge saying, yeah, okay, you've convinced me that this is important information that you need to have, and so I'm going to use the power of the bench to force that person or organization to give you that information.
Cough it up. Yeah, it's important to say, sometimes clients will come into the office and they'll say, Marc, I screwed up. I wasn't thinking. I did something stupid. Okay, well, if this was discoverable, in other words, if a prosecutor could force us to answer the question, tell me everything that your client told you, you could see very quickly clients wouldn't be able to tell their attorneys anything, and you wouldn't be able to get effective assistance of counsel, which is your Sixth Amendment right. So because of this, the law has carved out a privilege that the client has to say, I don't want my lawyer answering any questions about things that I communicated to the lawyer. Now, it's a little broader than that. It also applies to the lawyer's agents, like the paralegals, even the people at the front desk who answer the phone when people call. That's really important because sometimes people call a law firm and we'll say, okay, well, what happened, right? The person at the front desk is going to figure out, is this a criminal matter? Is it a civil matter? And the person might say, I made a big mistake. I did this or that. And, I screwed up. Okay, well, if the attorney-client privilege didn't cover all members of the law firm, they couldn't say anything to the person at the front desk. So this is a privilege that's pretty well protected. There are some little things that nibble at the edge, right? Like the fact that you called is sometimes something that's not protected, right? But what you said during the call, and of course it has to be relevant, right? That you called your lawyer in some way. And if a prosecutor sought to admit that into a trial, we would certainly oppose it. And the judge would be like, what's the relevance? But there might be some relevance that could be admitted. It applies to statements that the client makes to the lawyer and that the lawyer makes to the client.
A couple other things that are really interesting about when it attaches. Importantly, that attorney-client privilege attaches even before we formed an attorney-client relationship by terms of representation.
It's a great point.
Emergency, they call in. This happens all the time when people aren't our clients yet. Even before they're our clients and they've officially hired us, if we're giving them advice, if we're giving them legal advice and everything, all privileged, all protected, all non-discoverable. So I love that. And you can compare this level of protection that we have with this privilege with other levels of privilege that exist throughout our legal system. For example, everybody's probably heard of HIPAA laws and things like that. There's a certain privilege that a patient has with their doctor. But even that is penetrable in certain situations.
There's a doctor-patient privilege. There is a spousal privilege, right, under certain circumstances, most circumstances, things that people who are legally married say to each other. There's a privilege that's carved out because we don't want to see in the law, a husband being prosecuted and a wife called in and put on the stand and, hey, what did he say to you about this case?
There's even a clergyman privilege.
That's right.
That if parishioners go in into confession or something like that and tell their priest something, the idea here is, well, we want to be able to protect people's religious practices and being able to do this without them being scared to confess certain things to their priest. But even that stuff is discoverable under certain situations. As I always tell people, the attorney-client privilege is the strongest legal privilege that there exists in the United States of America.
Yeah, and it really makes sense because without that, you couldn't get effective representation.
So, to give you an idea how strong this is, guys, if you tell us that you plan on committing a crime, most of those situations, say that you come in, not only tell us that you committed the crime that you're being accused of, but you're also planning on committing another crime. Even in those situations, that's usually, we have to judge it and see if it's serious. We can have a conversation with you. And even that doesn't require us to disclose that information.
Yeah, and we're not talking about a property crime here. So to be clear, and I've said to clients on many occasions, if you say, hey, Mark, on the way in here, I intentionally ran somebody over and killed that person. Okay, there's no question that's covered by the attorney-client privilege.
No question.
We can't tell anybody.
Cannot tell anybody.
If you say, I'm getting ready to commit a theft tomorrow, we still can't tell anybody about that. It's only in the very thin area where the lawyer believes that the client told them something in the future that they were going to harm a serious injury or death to another person. Then in many states, it's a may. The lawyer may disclose
Even then, it's a may, right?
Yeah. So anyways, there are a few other little exceptions around the edges. But for the most part, this is the best privilege you get in American jurisprudence.
That's right. Okay, so why is it important during an emergency situation? So our AOR clients ask us this all the time. Guys, I'm in a self-defense situation. I had to discharge around. I was in fear for my life. I call the attorneys for freedom. I want some advice right there. Why is it important to have attorney-client privilege right in that moment?
Well, it's obviously critical because that's when you need the information, right? Usually the first thing I'm going to say, in fact, we just had a call a couple of days ago that I took, and the first thing that's out of my mouth is, are you somewhere where you can speak to me privately? Because if you're speaking to me and other people can overhear what you're saying, those people aren't covered by the attorney-client privilege. So it's only if I get a yes, Mark, there's nobody around. Okay, next question. What's going on? Tell me what happened. Everything that person tells me or you or one of our paralegals or someone at our front desk.
Even the front desk or anybody who works at our front.
Totally protected.
Yeah.
So why are we talking about this?
Well, because our competitors in the industry, do not have a law firm model. Instead, they have an insurance-based model. And the instructions that they give people who sign up for their programs is, okay, a bad thing happens, first call 911, then call our program and tell us what happened. And who answers the phone when you call one of those companies in a self-defense or emergency situation? A non-lawyer. And oftentimes, statements are made in that moment. I mean, you have to explain what happened.
Right.
You got to say where you are. Maybe you say some spontaneous statements. And because that is not a lawyer you are talking to, everything that you say is discoverable.
Yeah, and I don't think people really understand the gravity of this point. They want to call and say, hey, I was just involved in a shooting. Okay, that information right there could be important, right? Maybe it's not clear who was the shooter.
Maybe the state can't prove beyond a reasonable doubt who the shooter even was.
Right.
Or
So
that there was a shooting.
That's right. Or that you know anything about it.
Right.
So, but I'm just saying, anything you say, if you're not talking to an attorney, and it's not just any attorney, an attorney who is representing you. And so this person has to be an attorney who is giving legal advice to the person in an attorney-client type of an arrangement. Doesn't have to have any money exchanged yet. But if you're talking to a club or a corporation or some group that says, we'll get you a lawyer, that preliminary discussion is definitely not protected. And you know who knows about this?
Mr. Colie.
Prosecutors know about this. And yeah, that's right, Mr. Colie found out about it. And if you think that prosecutors are not savvy enough to recognize that people who call these non-law firm organizations, that they're not savvy enough to try to get records and information and recordings and everything that this entity knows about them, you don't understand prosecutors or how the system works.
All right, and we have a real-world example here, but before we get to that, a couple points to kind of put a bow on that last talking point. You gave a perfect example of where somebody calling one of these non-lawyers during an emergency is kind of shutting doors to their future defense attorney from bringing certain defenses. As you pointed out, maybe they can't prove that it was the shooter. Maybe they can't prove that they knew anything about it. Maybe they can't prove that there even was a shooting. Think of it like this. Every time you talk to a non-lawyer, certainly the cops, but definitely other non-lawyer witnesses, which is what you're creating when you call this hotline and talk to a non-lawyer, all you're doing is with every statement, you're potentially closing another door that your future defense attorney can use to defend you and keep you out of prison. But it's worse than that, right? Because what their statement might be might substantively close more doors. Say, for example, somebody calls one of these and says, I was in fear for my life.
Yep.
Okay.
But they tell you to say a lot.
Well, now you're stuck with a self-defense argument.
That's
What do
your
I
theory.
mean? What do I mean stuck on a self-defense argument? There are tons of other legal statutes out there all throughout the United States where you can justifiably shoot and kill somebody that has nothing to do with being in fear for your life. Defense of a third party comes to mind. There are certain crime prevention statutes where you can stop people from committing certain major felony crimes. There are just many, many different defenses, and all you're doing is you're just closing door after door that your future defense attorney would have been able to use.
That statement, publicly discoverable, I was in fear for my life, just closed off every other potential defense, legal defense in the case other than you were in fear for your life.
We've made videos about this before, but there are some otherwise reputable organizations out there that are actually dispensing this advice to their members. What you do in a shooting is you call 911 and you tell them, there's been a shooting, I was in fear for my life, here's the address, and I cringe every single time that I hear anybody say it. Why? There is no point in doing that. There's no point in foreclosing all those other defenses. So I thought that was an important thing to highlight.
Okay, so to Alan Colie.
You know, there's a real-world example of this stuff being discoverable.
Yeah, people know we've been looking at this case, right? Because this whole thing started months ago when we started asking questions, right? Someone in the Attorneys on Retainer program or somebody who follows our video contacted us and said, hey, there's this guy, he's a USCCA member, and he's got a public defender. And we started asking questions. Well, what happened? What's this about? We didn't know at the time. So one thing led to another. We wound up getting the file. And guess what we found?
Well, we found a subpoena that the prosecutor filed in order to get the court to make USCCA, the United States Concealed Carry Association, cough up a whole bunch of information about Mr. Colie. So that's what we're looking at right here. We have the request for subpoena ducis tecum right here, filed in the Commonwealth of Virginia by the prosecutor. And Marc, what do you have to say about this subpoena here?
Well, essentially, this is a request for the judge to issue an order to the USCCA to provide a whole bunch of things. And it's, of course, there's an affidavit that is connected to it. And here's what it says. I want to read from it in the affidavit. It says, I, Pamela Jones, Deputy Commonwealth's Attorney, having been duly sworn, do hereby certify that the items listed below items are material to this criminal case and are in the possession of a person not a party thereto. Copies of any writings, recordings, or documentation maintained in any manner by USCCA Inc., whether paper or electric, concerning Alan Walter Colie, and then the date of birth, platinum membership, then the number, including but not limited to all USCCA Inc. membership records, training records, fees paid, benefits provided and or available to, and certifications and or awards provided to Alan Walter Colie from the opening of this account until the present.
So that's an affidavit that was filed by the prosecutor in the case. And what we mean by an affidavit was this was a sworn statement. When a party tries to get the court to issue one of these subpoenas, they got to swear to the court why they believe it's important. And then accompanying this was another document, which is the request itself. And it says it's respectfully requested that the following items be produced in accordance with this request. Copies of any writings, recordings, or documentation maintained in any manner by USCCA, whether paper or electric, concerning Alan Walter Colie, and they got his platinum membership there. So it's very clear in this case that the prosecutor was certainly interested in anything that they could find from USCCA because they're not dumb. They know that there's no attorney-client privilege whatsoever with any of these things.
Now, to be fair, this wasn't granted. And the reason it wasn't granted, we understand. I think it was maybe erroneously filed the first time.
It's tough to tell exactly. We spoke to Colie's attorney, and he told us that they erroneously filed. They made a procedural error when they were filing it.
Maybe by the time they fixed it, it may have been too late, because I think that we got some information early on that the judge denied this request because it was untimely. You got to make these, this is what we call discovery, which is, hey, we're trying to get information from them. They're trying to get information from us. You got to do that well in advance of trial. And if it's not done early enough, a judge can say, sorry, I'm not going to grant this request. It's too late. You should have done this months ago. I don't know why they maybe didn't do this earlier. It was denied, but that's not the point. The point here is, what if it was granted? Who knows what information USCCA may have had? Who knows who may have answered the initial phone call and whether that was recorded and what that person might have recalled, truthfully or mistakenly, about what was said by Mr. Colie to the USCCA.
Yeah, even if it wasn't recorded, the prosecutor would have the right, if this was granted, to figure out what is the name of the employee at your answering service who took Mr. Colie's call. Okay, we're getting him in for a deposition. We're swearing him in under oath. We could put him on the stand. And the question could be, tell me every detail of what Alan Colie said to you when he called the USCCA immediately after the shooting.
They could call people who are involved in the insurance company, people involved in the corporation who were involved in making decisions about whether they were going to cover this or not.
They could put them on the stand and say, like, let's say it was a case where they denied coverage, like many people believe about the Colie case. If you want to see into this controversy, you just go look at some of the things we've said on the matter. But assuming that coverage is denied in a case, the prosecutor, if this type of a thing was granted, could put the person who made the decision to deny the claim on the stand or get them into a sworn deposition and say, why did you decide to deny the claim? Well, we strongly believed it wasn't self-defense. Oh, and why is that? And tell me who else you spoke to about it, and tell me about why you guys denied coverage. And they could present that stuff potentially to a jury, which would be extremely prejudicial.
Think about the magnitude of this problem. Also, this is what happened in the Alan Colie case, or it almost happened in the Alan Colie case. Think about the Kayla Giles case. In the Kayla Giles case, right, because remember, the insurance company needs to know what happened so they can figure out whether they want to cover it or not. Well, in that case, USCCA ponied up $50,000 to an attorney, as we know, who started to represent Kayla Giles and told us specifically he thought it was a very defensible self-defense case. There's another video that we'll be releasing soon. It may be before or after this video. Maybe we can put a link into it if you want to see exactly why we think that was a defensible case. There's a video we did with the use of force expert Jeff Hines. But in that case, what happened was that lawyer was required by the terms of the contract to provide information about the case to the insurance company. And then the insurance company decided to deny it. They told the attorney, look, you're off the case. We're not paying any more money. But that conversation as well, even though it involves the lawyer, it doesn't involve the lawyer and the client. And so when that lawyer, by contract, is reporting information to the company or the insurance company, all of that is also discoverable as well. The only thing that's not discoverable here is the conversation and information that flows between the client, who might be a defendant in the case, and the lawyer or agents of the lawyer's law firm. That's all protected. But if you're dealing with conversations between the client or the defendant in a non-law firm, or conversations between the client's lawyer and the insurance company or non-law firm, none of that's protected, and it's all discoverable.
Confidentiality is so absolutely important, and the attorney-client privilege is so absolutely important. The whole criminal justice system, in order for due process to be exercised, absolutely critical. And even in different hypotheticals that you and I have encountered time and time again, such as when somebody calls our law firm first and they're trying to decide whether or not to call the police, right?
Yeah.
This happens all the time. And we say that this is another avenue where we disagree with a lot of the information that's being suggested by other organizations out there. Most organizations that I've seen say, first call is always to 911 if there's a discharge of a firearm. Second call is to your attorney or the organization or whatever it may be. We disagree with that too, assuming that human life is not in danger after the shoot. Like, for example, if it's a negligent discharge or something like that, we strongly advise against calling 911 first.
And
you should call to us first, and all that information totally not discoverable. Like if it's determined later that there was a witness or somebody did hear a gunshot, if there's a negligent discharge and reports it to the police show up and arrest you, the contents of our call with that person will not be discoverable.
Yeah, as a side note, we've had many people who've called us in those types of cases. We've said, don't call anybody, and that's been the end of it. There's also been cases where there have been those types of incidents. People called the police first, then called us, and they actually got themselves charged with a major felony that requires mandatory prison time. So in these different reviews that I've done on these different companies, I usually breeze past this as I go through their contract, where it says something like, hey, the attorney is going to be required to give information to the company, and the client is going to be required to sign a waiver of the attorney-client privilege or give consent for their lawyer to talk to the company. They need that so they can evaluate the claim. And I sort of point out that that's a problem. Hopefully this video will further explain the magnitude of that particular problem. This is why, might seem obvious, you got a criminal law problem, you need to talk to a criminal law attorney who's representing you.
Not an adjuster at an insurance company, not somebody who's a representative working in a call center for a gun club or something like that. You need actual attorney-client privilege to attach to that conversation in order to make sure you're fully protected.
And you call that attorneys on retainer emergency line, you will, within seconds, be talking to Marc Victor, Andy Marcantel, or one of the lawyers at our firm, or like one of our AOR clients found out, you may be talking about to 5 lawyers, right? We had a client recently, people can check our Google reviews. I think there was one that was put out there on this, where within seconds, the person who called the emergency line had all 5 of us in the office chatting it up.
Yeah, and we keep that open 24/7, 365, because we know that these things, you don't get to choose when a self-defense incident occurs, and we understand it can happen in the middle of the night. It could happen on a holiday. That's why we have the line. That's why it's always open. There are always attorneys standing by to have a conversation, a privileged conversation, and give you advice in that moment when you need it. Any last thoughts on this, Marc?
I think we beat it to death. I think people understand exactly what attorney-client privilege is, why it's important, why we have it. If people don't, then they can either email us directly and say, hey, I still got a question about that, or leave a comment in the video below. Usually we'll get to those as well.
All right, everybody, if you want to check out attorneysonretainer.us, you're going to learn all about our awesome program and what it can do for you. Learn more about our law firm at attorneysforfreedom.com. And as usual, if you liked the video, leave us a like, subscribe to the channel, leave a comment down below. And until next time, my friends, has been attorney Andy Marcantel and attorney Marc J. Victor. Peace.